John, I was just looking at the letter from the on your website regarding your reaction to the Wittich trial. Just in a few words, would you capsulize what this meant to you as the Commissioner of Political Practices, being able to successfully litigate this case, which I know involved a lot of work and a lot of teamwork from folks who, from what I understand, actually donated their time to make this happen. What did this mean for you and for your office?
Well, I think that the first thing we got to say is that I guess our office's position on the involvement of the National Right to Work Committee with the 2010 candidates, it's as far as Mr. Wittich is concerned, it's the rear-view mirror now. We have a jury decision saying that Mr. Wittich received about $20,000 in illegal corporate contributions, and he failed to report and disclose about $20,000 in illegal corporate contributions. So, to circle back to your question, I think what it does is it takes a big burden off of our office, because now it's adjudicated, it's a jury decision, it's a court decision, it's no longer a commissioner's decision.
Now, was this relatively unprecedented in the history of the Office of Political Practices to take this this far to a court with a jury to decide all this?
Well, it's unprecedented from a candidate or a public official perspective. Our office issues an administrative decision called the sufficiency decision, and then works with a candidate or political committee to try to resolve and settle that. And the principles of resolving and settling a sufficiency decision is the political committee or the candidate accepts responsibility, apologizes to the people of Montana, pays a social data fine, and corrects the filing report. Those are the four principles that we use when we settle a case. And you can go on the website and you can see the sufficiency decision, and if it's resolved, right next to it there'll be a settlement agreement. You click on that, you can read it.
Sure. Now, in my conversations with, of course, I'm in Missoula, and of course that's where the attorney, Mr. Rhodes, is for Mr. Wittich. Visited with him, and his reaction, obviously, they were very disappointed. They thought the trial was going well for them, and then when the 10-2 decision came down, they were disappointed and surprised. One of the things that he brought out was the fact that he believes that this decision by the jury and the pursuit by your office of this matter may tend to make and his words, a chilling effect, end quote, on other conservative candidates who may want to run for office. As a matter of fact, he has said that some people are not even returning questionnaires anymore because they simply don't want to have the trouble of possibly, running into trouble with your office. So how can you respond to that, sir?
Well, it's just the opposite that we've been hearing. That is that there is a great deal of relief and a sense of freedom being expressed by a large number of candidates who perceive themselves as being the likely next target of this just unprincipled, unreported, undisclosed, and dark money campaign run by National Right to Work in this case. So we've been hearing just the opposite, and in fact, there were two Republican candidates who testified at trial, Mr. Moran, who ran against Mr. Wittich, and Mr. Esp, who ran against another one of the National Right to Work supported candidates, Mr. Wittich, and both of them just expressed the amount of angst and the amount of harm to their family that was caused by the activity that is now restricted by this decision. So that's a fine spin by Mr. Rhodes. It is a huge disservice to the intellect and principles of Montanans as demonstrated by that jury.
Okay. Now, I just happened to, at the post office this morning, I ran into Gary Marbut, who is the president of the Montana Shooting Sports Association, and he had mentioned that he had visited with you regarding some questionnaires that he had sent out. He wanted to make sure that that those who responded to the questionnaires would not face any difficulty from your office, and he said he reiterated that to you again very recently. Is that something that you can confirm that an organization like his would be not necessarily free of perusal by your office, but that they're doing things right?
Well, so there's a nuanced answer to that. There were, of course, questionnaires used by the corporations that were working with National Right to Work in these 2010 Republican primary elections. Those questionnaires were actually coordinated with Mr. Wittich. That's what the jury found. And that the information produced on those were used for the benefit of Mr. Wittich and against his opponent. That type of questionnaire, because it is coordinated with the candidate, is an illegal corporate expenditure. Now, if in fact an entity is doing a questionnaire solely on its own and is not coordinating with any candidate, then that is a speech right of that corporate entity, and they can, of course, engage in that.
Okay. So now, as we go forward, and of course we have a political season here, an election coming up in November. Of course, we have a primary coming up. Most of the candidates have already declared. But going forward, what advice would you give Democrats, Republicans, Independents to keep from running afoul of problems like this that could cost them court time, lawyers, all the things that Wittich went through with this trial?
Now, that's a loaded question, Peter.
Okay.
Mr. Wittich requested the jury trial.
Oh, he did. Okay, I'm sorry. Yeah.
And Mr. Wittich filed 29 motions designed to prevent trial.
Okay.
He won all 29, even to get into court. The fact that this case is into court, the fact that we had to adjudicate it, is Mr. Wittich's choice. So it is pretty hard for me, having gone through the pretrial ordeal, to even get into court and then present this case to court, to feel that Mr. Wittich was in somehow brought to task by some unfair public entity. It is the reverse. It is his choice to be the first adjudicated candidate in 75 years. He put himself where he ended up. Now, to another candidate running for office, I would say this. Our office is friendly. I have heard nothing but praise for the way in which our staff interacts with candidates. We work on behalf of candidates. We appreciate that candidates are running. We serve candidates just as much as we serve the public when we have to deal with an errant behavior in a candidate race. So my suggestion to candidates is talk to us. Mary Baker's here. Kim Trujillo is here. Alyssa Spaeth is here. They will take your phone calls. They will talk to you. But I would caution anybody who would try to make a general application out of the Wittich jury trial to all candidates. That is not true. It is not the case. There's a reason why he's the first public official in 75 years to be adjudicated a campaign practice violator. And when that happens, it's the same agency that has been in place, well, not the whole 75 years, but since 1975. And it hasn't happened before. So it is illogical to say it is the agency. You've got to look to the candidate as well.
Okay. One more quick question, and this is a question I have to ask, is that is there any sort of a bias one way or the other from you and your office, either for or against Democrats or for or against conservatives or Republicans or liberals or anyone who wants to run for office in Montana? I think that's a very important question that needs to be asked.
Well, and I think it is So here's my answer to that. The simple answer is no. But the more complicated answer is we are aware of that public perception because it's been raised so many times, primarily by Mr. Wittich, that we guard against it. We have vetting processes in place that are designed to make sure that one person is not making decisions. In the end, of course, our authority flows through the commissioner. The commissioner has to make the decision. But we vet, and we work in teams. And we're all Montanans here. There's only 7 of us, but we're Montanans. And no, we work diligently to prevent that exact sort of thing from happening. We approach everything equally.
Is there an agency above you that if someone feels that they've been unfairly treated that they can go to?
Well, and there, that's a good question. And here's the answer to that. The commissioner, and that's the authority this office exercises under, can be removed from office, can be impeached for malfeasance. The commissioner is subject to appointment by the governor, to confirmation by the Senate. The commissioner is subject to 1 term. That is, the commissioner can only serve once, and the term is 6 years. It doesn't matter how many commissioners fall in that 6 years. I happen to be the 4th in this 6-year cycle. You're not eligible for reappointment. With all those safeguards built in, the commissioner is free to operate within that 6-year period of their appointment without any higher authority, and it has to be that way if you think about it. The commissioner may be asked to investigate, I just was asked to investigate 2 statewide public officials. And of course, when the commissioner does that, it's a vetting team. Everybody works on it. There's a team of people that work on it, but it's still issued under the commissioner's signature. Because the commissioner is expected on behalf of the people of Montana to provide that public trust review of the ethics, lobbying, and campaign practice activity, potentially, of any sitting public official. You can't have a sitting public official able to reverse. If you had that, you would have the Saturday Night Massacre where Archibald Cox was removed by Richard Nixon. No, there isn't going to be that sort of check in Montana. Wisely, when the law was set up, it was set up with the balances I described earlier, but the purpose of the commissioner's office is to provide to the public, within that limited area of ethics, campaign practice violations, and lobbying, a way that the public trust can be enforced on behalf of the public, no matter who it is enforced against, no matter how powerful they are, no matter what political party they are, no matter how wealthy. That public trust obligation applies to everybody.